Hi there, my name is Chris Richards with Richards Mortgage Group. I've been a licensed mortgage broker since 2008. I get a lot of calls and inquiries on my website about divorce and separation and what to do with property and mortgages upon a pending relationship breakdown. I'd like to expand the definition of a relationship breakdown. Besides married couples, it also relates to common law partnerships and any kind of joint purchase that was made, let's say, between siblings or between a parent and a child, any situation where that relationship is breaking down. So this video is meant to help clarify the decision-making process and the order of steps that you will need to go through in order to separate your financial affairs and get out of a joint mortgage, or to position yourself for the next mortgage post-separation. So the first step, if the relationship is ending, is you need to reach agreement on the division of the matrimonial assets and debts. So what are matrimonial assets? That's everything you've acquired together in your relationship. What are matrimonial debts? They're all the debts that you've acquired together during the relationship. So figuring out what you own and what you owe is a big part of the separation process. And there are a lot of really good guides on the internet to help you through that process. Here is an example of one. It's called Property Division for Married and Unmarried Couples. So I've put those links down below. I've got one from Alberta, one from Ontario, one from BC. And if you want to find something that's more appropriate for your province, simply search Property Division Divorce in your Alberta, BC, or Saskatchewan, whatever your province happens to be. Also in the links below, I've provided a separation checklist, and that'll help you guide yourself through the process and list all of the questions and things that you need to consider or that may need to be addressed. So it's really important to understand that during a relationship breakdown, that mortgage lenders are unable and will not do business with you until you sort out your finances. They have no idea what obligation one spouse is going to have to the other, whether there's child support, alimony. There's a lot of uncertainty there, and that part has to be figured out as a precursor before any changes to mortgages, before any new mortgages, or any changes to land titles or deeds can be made. So the second step for you guys is, how do you agree on who owes what to whom? So not how do you agree, but how do you reach agreement on who owes what to whom? And there's two ways. One is the easy way, and the other is the hard way. The easy way is you both cooperate and work together and get yourself through this storm. The hard way is you don't cooperate, in which case you are likely going to need a family law lawyer. And the worst case is one party has to take the other party to court and get a court order to make this happen. The hard way is going to cost a whole lot more money than the easy way. In terms of worst case scenarios, I've seen where one party drags the other into bankruptcy and foreclosure, which will set you both back financially for 6 or 7 years, not to mention the emotional impact of a long, drawn-out separation. So cooperation is a much better choice. So please visit the links below, which provide a lot of value on how to divide your assets and debts. And by all means, share this page with this video link with your partner. All I can urge you guys is please cooperate. It goes a whole lot better. So one way or the other, ultimately, you need to arrive at a financial separation agreement, whether you've mutually agreed to that and negotiated that in good faith, or you've got a court order. In that regard, when there's a financial separation agreement, all of the assets and debts have been added up and have been listed, added up and subtracted, and there's an amount that one party owes the other, and that's called an equalization amount. Also, I want to point out is that if you're going through a financial separation or a divorce, there are also obligations that one party might have to the other as it relates to spousal support or alimony or spousal support or child support payments. And those payments are debt obligations for one party and income for the other. So they very much matter in a mortgage application, hence why mortgage lenders require you guys to have your separation agreement largely financed before we can start doing some what if scenarios and getting some solutions for you. So you've got this basis of your financial separation agreement coming along. So the next step is, how do you divvy out the assets? How do you get enough money to pay out the joint debts? Who gets to stay in the house if that's desirable? So in a financial separation, the joint debts typically must be paid out and those accounts closed. You want that. You don't want your spouse having access to your credit card or vice versa. And another joint debt that must be paid out is the house mortgage. So the next logical question is do you keep the house or do you sell it? If you sell the house, you simply take the equity, you pay off the mortgage, there's some residual left over that pays out the joint debts, and anything that's left over gets split according to the separation agreement. Perhaps that's 50-50 and that part's done, the separation is complete, and you move on to a divorce in a year on the advice of your lawyer. If one of the party wants to keep the house, in the mortgage world, the terminology is that's called the spouse to stay, and the spouse who is leaving the matrimonial home is called the spouse to go. So if you are the spouse to stay, the next question you want to ask a mortgage person is, can I qualify for a mortgage on my own so that I can keep the house? So to qualify for a mortgage, you have to have sufficient income, credit, and equity. So on our website, we have how to qualify. Can I get a mortgage, or how do I qualify? So that describes everything as it relates to getting a mortgage. This is no different. So just to go through the qualification steps quite quickly, your income needs to be stable and sufficient to carry the new mortgage plus any remaining personal debts that you're going to keep. Your credit needs to be reasonable. That means you've got no active or recent collections or late payments. And as it relates to down payment or equity, there needs to be enough cash within the home to pay off the existing mortgage, pay off the joint debts, and make any required equalization payment. So it sounds a little complicated. It's not as bad as you think, but it can get a little complicated. In a relationship breakdown with a separation agreement in hand and with sufficient income, credit, and equity, you can generally refinance the home up to 95% of its fair market value. And from that 95%, your lawyer, will repay the joint mortgage, will pay off the joint debts, and make the required spousal equalization payment. And it's important to note that you can't get extra cash out to pay non-joint debts or to put money in your pocket. That part's not permitted. So I can help you determine whether you would qualify for a mortgage to buy out your spouse and whether there's enough equity to execute what's written in your separation agreement. You need that separation agreement if it's not clear. If you cannot qualify for a mortgage on your own, you have two options. One, you sell the house and pay off the mortgage and all the other matrimonial debts. And to sell, you both have to sign the listing agreement with the realtor. You will both have to accept an offer to purchase. I also want to point out an important concept called dower rights. And what dower rights are even if a spouse is not on a mortgage or the title, you still have rights to the property. And the other party cannot act unilaterally in a manner that would violate dower rights. So even when they sign that listing agreement, there's a question about dower rights and who's lived in that property. So let's say you want to sell the house, but you can't sell the house, or a spouse wants to stay in the spouse wants to stay in the house, but they can't afford to qualify, or they don't have the credentials to qualify for a mortgage on your own. There is a way, if both parties want to cooperate, where the spouse to stay actually becomes a tenant in the property, and that same spouse and the spouse to go form a joint venture partnership such that the joint venture partnership is a landlord and the spouse to stay is a tenant, and the spouse pays fair market rent to the joint venture, and the joint venture pays the mortgage, the property taxes, repairs and maintenance, etc. Just as any people might form a partnership to invest in rental properties. So that's a little bit more complicated. I can consult on these types of transactions on a fee for service basis. I'd charge similar to what a real estate agent would, or sorry, what a lawyer would on a real estate transaction. So a few warnings and advice. It's important to know that one party in a relationship cannot legally renew or cancel a joint mortgage or any other joint debt for that matter without the other's permission. That's what the joint means. Mortgages that come up for renewal during the separation process usually have a default open mortgage if the renewal agreement cannot or is not signed. It's important to know that an open mortgage is much more expensive than what we call a closed mortgage with regular terms, and that could cause the mortgage payment to go way up and create even more financial hardship. So if you are separating, it's likely good advice to advise your joint creditors, including the mortgage company, what is going on, and get their guidance on how to protect yourself financially. It's also important to note if your partner is going to be reckless with finances, you should get legal advice immediately so that they don't bring you down with themselves. So in summary, I can help you if you have a financial separation agreement draft, you figured out your assets and debts and how it's going to get split. So you've got a financial separation agreement in the works, and you're now looking at mortgage finance options in order to determine if you can keep the house potentially, or if you need to sell it. If you are the spouse to go and you want to make sure you are positioning yourself to re-enter the housing market post-separation, I strongly recommend you call me so that something that's going on doesn't inadvertently harm your financial situation as it relates to mortgage qualifying for the next property. So in either event, as a spouse to stay or a spouse to go, if you think you can probably qualify for a mortgage, you've got the good job and you've got reasonable credit, I can tell you in a short conversation what is available for you or what steps to make. And I'll ask for you is that you've got some clarity on your separation agreement. So again, look at those links and start to understand how to divide out your assets, get your spouse on side, and work together to try and come up with an amicable relationship. You'll probably need family law lawyers regardless to put this all in writing when you're done. So again, my name is Chris Richards. I'm with the Richards Mortgage Group. Our number is 1-888-540-1715. I'm extension 2. Our contact information is also on the website, and there's a chat message somewhere down below. So hope to hear from you soon. Hope this has been a good video for you. Have a great day.